Okay, this is cause number 327008, case of style, the state of Texas versus Leonard M. Head. M stand for Mark, is that
Mark, yes,
correct?
sir. My friends call me Mark, yes, sir.
Okay, how you doing, Mr. Head?
You call me Mark too. I'm good.
Okay, now, Mr. Head, I see here, well, let me just do this here. I have before me a document that is titled Judge's Explanation of Rights of Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that says defendant?
Yes, sir.
And you have a set of initials on the line that states that you waive your right to an attorney, you want to represent yourself?
Myself, yes, sir.
Okay, and also there's another document here that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this
Yes,
document?
sir.
And is this your signature on the line that says defendant?
Yes, sir.
Okay, now, Mr. Head,
Yes, sir.
prior to signing and initialing both of these documents, did you have an opportunity to review the documents?
Yes, sir.
And did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir. I could,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir. I mean, I get it. It's on my disability. I could get it. A lawyer, no point about always takes money.
Okay, but I'm just saying, right now, you want to represent
Yes,
yourself.
sir.
That's what you're saying. Okay.
Takes money.
Now, you've had an opportunity to talk to the prosecutor about your case to see if y'all can,
Yes, sir.
you reach a plea bargaining agreement, and y'all have not been able to reach a plea bargaining agreement. Is that correct?
I didn't.
Okay,
I
I'm-
believe in the
Miss-
flag,
Mr.
and I
Head,
believe in the
Mr. Head,
judicial system.
Mr. Head,
Yes, sir.
would you please listen?
Yes, sir.
Okay, and then if I have any questions, I can actually respond.
Yes, sir.
You can't, both of us can't talk at
I
the
got
same
you. Yes,
time.
sir.
Okay, so you and the state have been unable to reach an agreement, is that correct? And so therefore, since you and the state have not been able to reach an agreement, you have a couple of options. One option is you can proceed with what is called an unagreed plea, and that simply means that if you still want to plead, that the judge I will set the punishment. At that point, you don't know, the court doesn't tell you ahead of time what that will be. Or if you want to set your case for trial, you can reset your case for trial. And in between the time that your case is set, well, actually your case, if you say you want a trial, we'll set your case for what is called after that an announcement. And what an announcement is, it's an opportunity to tell you, it's an opportunity for you to tell the court or to announce to the court what you want to do. Now, in between that time, you'll have an opportunity to have what is called discovery. And I think during arraignment, I explained to you what discovery was. You have an opportunity to have access to the evidence that the state has against you in your case. Now, so just tell the court, you can tell the court what you want to do in reference to your case. Do you want to set your case for a trial? Okay, good. Okay, so let's give him an announcement date. And we're going to give you about, let's say 60, well, Mr. Boyd, how much time do he needs, so he can have access to, so that he can have discovery?
60 days would be fine. You just have to set up an appointment with our office to come view the discovery. That's what we do.
Okay, let's reset it for 60 days.
January the 3rd.
Okay, now, Mr. Head, your case has been reset to January the 3rd. You can stand on the far X. Once you stand on the far X, court coordinator give you a reset date. Once you get your reset date, you'll be free to go. You have a blessed day, and make sure you just have to stay in contact with the DA's office.
I've always felt guilty for what I've done wrong.
Well, okay. Okay. Ms. Trustee Ross. Oh, this is it? The income.
She get
Oh, she live in public housing too. Okay.
I'll write it in the paper.
Now, Ms. Ross, I have before me a document that is titled the affidavit of indigence. Now, I also have a document that is titled Judge's Explanation of Defendant's Rights to Without an Attorney. Now, Ms. Ross, you recognize both of these documents?
Yes, sir.
Now, you've signed one of these documents, is that correct? And you also initial the document that is judge's explanation of rights, stating that you like to apply for court appointed counsel, is that correct?
Yes.
Now, Ms. Ross, prior to signing and initialing these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Ms. Ross, in reviewing your affidavit of indigence. Ross. Okay, Ms. Ross, in reviewing your affidavit of indigence, you apparently you are automatic qualifier. That simply means that you meet the eligibility requirements for the appointment of a court appointed attorney. And your attorney in this case is going to be a lawyer by the name of Terrence Allison.
Go ahead and try this number again. And, yeah, because he's your phone. And you, that's your phone.
Okay, now, Ms. Frost, as I said earlier, your attorney that has been appointed to represent you, name is Attorney Terrence Allison.
Yes, sir.
And Ms. Frost, you're gonna stand on the 4X in front of our court coordinator and follow her directions. And once you finish here, you'll be free to go, and you have a blessed day. Allison, Terrence Allison. That was Mr. Head.
Yes, sir. She on the first page. So it's, I don't, that's correct.